Every day in the USA, people find themselves in court.
Here's this. Thank you.
Yes, sir.
And we now call cause number 23 CR 1439, the state of Texas versus John Walker Bordash Jr., who is present with his attorney, Mr. West, and the state's attorney. And the court had earlier ordered, I think, agreed in an agreement by all parties that the defendant undergo an examination for competency. Dr. Ed Rapond, licensed psychiatrist, was appointed to handle this matter, and we have received a report dated February 3rd, 2025, with his analysis. And the parties had an opportunity to review it, state and defense.
Yes, Your Honor. Yes, Your Honor.
I'm going to identify and describe this as court's exhibit number 1 on this docket on this date. It's called, referred to as court's exhibit number 1. It will be placed into the record for the purposes of this hearing. Any objections, state
No, Your Honor.
and defense.
No, Your Honor.
All right. Is there anything anyone wants to add from the state on this matter
No,
in
Your
this hearing? What about you, Mr.
No, Your
West? Nothing to add? Mr. Bordash, you're a PhD, so
Yes.
you've earned being called a doctor. You had a chance to review this with Mr. West?
No.
The report?
You have to look at it real quick. Yes.
You should do that. Thank you. Go ahead. Y'all
Oh, you want to go?
go, whatever you get in private, you go over with him. He has a right to know what that is. Are you here in
Yes,
this
Your
one? We now call cause number 23 CR 1439, the state of Texas versus John Walter Bordash Jr. The defendant is present with Mr. West, John West, his attorney, and the state's attorney. We are picking up a matter as soon as we have gotten the information concerning the matter of competency concerning the defendant. A motion suggesting incompetency and request for examination was filed on in October of 2024 by the defense, and we had some matters taken up in the meantime concerning the defendant's placement on bond. This indictment of the defendant was handed up by the grand jury on September 20th of 2023 and has been pending. And we've had some matters over the course of that time concerning defendant's bond and whether his bond should continue based upon circumstances that were brought to the court's attention. Then the defendant was placed on bond, and then later his bond was revoked by this court upon a hearing determining that the bond conditions were not being met properly by the defendant. A motion suggesting incompetency and request for examination was filed again in October of 2024. The court ordered Dr. Ed Rapond, licensed psychiatrist, to conduct an analysis and evaluation of the defendant. That was done. We have received Dr. Grapon's report dated February 3rd of 2024. And the court has given copies of this to the state and to the defense. So in summary, upon evaluation, Dr. Grapon's report includes information about Dr. Ed Grapon, where Dr. Grapon is a licensed psychiatrist. This court is well informed of. I believe I first met Dr. Grapon when he was brought into the James Byrd murder cases that this judge was part of the prosecution of in 1998. And Dr. Grapon analyzed defendants and testified during that trial. So the court has known him since 1998 and known Dr. Grapon to be a highly qualified man and has his medical doctorate in psychiatry and has evaluated countless individuals in his civil practice and in criminal cases here in these courts in Jefferson County for decades. And his reputation is pristine on his abilities and his competency in doing his job. He has prepared a 5-page report after evaluating Dr. Bordash at the request of this court, after this court found good cause to have Dr. Bordash evaluated. And it has been made a part of this record as Court's Exhibit 1 for this hearing and any other purposes that are relevant to the defendant's competency. And within the report, the doctor details his interaction and his speaking with the defendant and deems that the defendant is quite apparent in his words. Bash demonstrates significant paranoia, particularly in regard to the legal system. His judgment is impaired. His insight is almost nil. He is diagnosed by Dr. Grapon with delusional disorder, non-bizarre. As to competency, the defendant is not competent at this time to proceed to a resolution of his legal issues. He does not possess in his current state the ability to communicate with his attorney with a reasonable degree of rational understanding in the preparation of any defense. The defendant is mentally ill by definition. He would require involuntary psychiatric treatment intervention for restoration of competency. He has no insight into his condition and adamantly believes he is being victimized by this situation and the legal proceedings surrounding it. It is very unlikely that he will accept that he is operating under a totally false belief system. He states repeatedly he is the victim of electronic harassment perpetrated by his neighbors. And when asked about any of his legal difficulty, according to Dr. Grapon, the defendant gives a very paranoid and/or delusional explanation for the total scenario. All right, then the final determination is that the defendant is mentally ill, is incompetent, and needs a hospital treatment, inpatient treatment at a proper facility of the state, with our hope of him gaining competency to stand trial in this case. Anything the state wants to add to this report?
No, Your Honor.
What about the defense?
I do not, Your Honor. However, my client has reviewed this report and does not agree with the report.
Okay.
And did want to address the court. But I will stand by the report. I'm the one that requested the competency in the first place, so I don't believe it's competent. So I believe the doctor's suggestion is correct, but my client does want to address the court.
Okay. Is that right, Dr. Bordash? You want to make a statement?
Yes,
Raise your right hand. Do you solemnly swear or affirm any statement you make will be the truth, the whole truth, and nothing but the truth? So help you God.
yes.
All right, lower your hand. I think you marked, I gave Mr. West a copy of this. You marked on that document. It's a duplicate. It's a duplicate of a true and accurate copy of what the court received from Dr. Edgar Pond, and I marked that as court's exhibit number 1 that you referred to and make notes. I didn't read your notes, but you can refer to those as necessary if you wish, and that's for you and your attorney to have. Go ahead. What would you like to add, sir?
Oh, well, Dr. Papon says I performed a standard psychiatric interview with the formulation of a formal mental status exam. No, he did not. I was not given the mini mental status exam, MMSE, and the Montreal Cognitive Assessment, also called the MOCA for short. And page 2, I guess he, third sentence from the bottom. It says he denies a history of mental health treatment, but has for a number of years been under the care of local psychiatrists for a diagnosis of narcolepsy, for which he takes Adderall on a daily basis. Actually, I acknowledge a history of mental health treatment for neurocognitive issues, for example, attention, concentration, processing speed, and motivation. And let's see. And has been for a number of years under the care of a local psychiatrist and some in Houston for diagnosis of HIV-associated neurocognitive disorder and narcolepsy, for which I take Adderall on a daily basis. But it also helps with trigeminal neuropathy. Second, the next sentence, he does report that he has had essentially annual neuropsychological evaluations done over the past 10 years because of concerns about cognitive issues. That is true. However, it is because that I've been conscientious of ethics issues pertaining to competency for a long time because of my condition. And I have volunteered to undergo neuropsychological evaluations on an annual basis to confirm that I can continue to work on a part-time basis. For this reason, I've been showing conscientious. I've been very conscientious about the ethical issues of competency. And I have been having Dr. Mario DeLay, Methodist Hospital in Houston, in the medical center, conduct these evaluations since 2011. Next page. Dr. Rapon says he reported that the date of his next examination was due to be at the end of January 2025. Yes. And a neurology consult was also set up by me for January 20th, 2025 at 3 p.m. with Dr. Mary Bowe, B.O., M.D. Let's see. The sixth sentence down. Apparently, this involves some interactions between he and the neighbor, which he seems to have generated by his delusional belief that they are somehow adversely affecting him through electromagnetic waves. Now, my response is, whereas I acknowledge that in the past, patients were at one time considered delusional when they made these kinds of remarks, recent research over the past 10 to 15 years would suggest that there is some scientific validity to these claims. And certainly the World Health Organization has adopted electromagnetic hypersensitivity syndrome as part of the ICD-10 diagnostic code book. The next one is, let's see, where it says affect is generally appropriate, although he has a number of somewhat paranoid ideas in regards to the legal system, the reason for he is in current legal difficulty, etc., etc., etc. Actually, no, I have reservations, not paranoid ideas. And the next one is he has a fixed delusional system in regard to what he feels are health-related problems that he is having because he is absolutely convinced that his neighbors are poisoning with microwaves from their home, to his residence. No, I'm able to distinguish when symptoms of microwaving are occurring and when they are not, and to discriminate between who is most likely to engage in such deadly conduct. The next one is, he basically told me that he has had some type of device which would read the strength of these electronic impulses, and he could determine that they were coming from the neighbor's residence. It's really kind of well, not specific enough. Actually, on any kind of cell phone device, you can download applications that are written specifically to detect electromagnetic waves and their strength. Actually, you can see on any cell phone that there's a antenna icon with that gauges the strength of the signal that you're receiving. And so that's the same sensor that is being used by these applications. The one I was using is called gauze meter. Gauze is a measure of the strength of a magnetic field. And it can also be measured using units called Teslas or microteslas. And these applications, the one I ended up using more than the other was gauze meter, because I can take constant readings up to 300 seconds intervals and locate where hotspots were being found in my home. The first one was in the right bracket of my shower. It would sometimes the readings would be as high as 5,000 microteslas or higher. And then on the shower wall that separated the jacuzzi, those readings would go down to maybe 3,800 microteslas. Past that is my master bedroom closet. In line with the shower wall bracket, readings could go down to about 25 microteslas. And then in the garage, about 10 feet from the garage door itself, which is still in line with the shower, the readings would go down to about 2,000 microteslas. Now, the progressive decline in strength of magnetic fields would indicate that it's coming from the direction of my neighbors. They have never had a white tent put up in their backyard before, until I started having these experiences, and so they are coming from that direction. I've also determined that at times the whatever device is in that tent is sometimes shifted, and the I pick up high readings around between my bedroom window and where I lay my head on my bed. Since then, I have put in a door glass, a pane of door glass from a previous office because glass is used as an insulator for magnetic fields, electromagnetic fields. And that was enough to reduce the signal strength from about 2,800 microteslas down to about 700. So about a 75% decrease in these strings. I've also put jugs of water to try to absorb the rest of the microwaving. However, that proved to be kind of messy because by morning time, the jugs had expanded because of heating and leaked onto my.
But allow me to interrupt, just please. I think I understand. You are in more detail, but repeating what you had earlier toward the court before in previous hearings on this matter. Let me ask you what you've never articulated to this court clearly is why would your neighbors do such a thing that you think they're doing to intentionally cause you harm by this surreptitious, microwave attack on your mind?
Okay, not on my mind,
Why?
my person.
Why would they do that? What do you think the motive would be if this is true?
Well, it could be religious objections to my sexual orientation and the fact that I was in an interracial relationship. I mean, years ago, we had,
Okay, you think that might be it?
that might be it, amongst other things. The fact that I suspended fees because Miss Peyton showed up at my door making ridiculous claims that I should pay my fees because we needed to replace the street. That street won't be needing to be replaced for another 75 years. So I don't think.
Are you talking about homeowner fees?
Yes.
Do you?
I don't think we should be taking up, paying fees when neither one of us is going to be alive when that street needs to be replaced.
What else do you think? What else?
And the fact that, whenever we had a homeowners association, which I have not been invited to for ever since Mr. Warren, Vanessa Yates moved into my home, a gentleman of color with whom I had a relationship for about 25 years, and lost him to a number of factors that were
Is there any?
terribly heartbreaking.
Okay. Otherwise,
Anyway, we used to have lawn care service that was provided by a Black-owned a company, okay, and they did a good job. That all changed when because Miss Peyton and Mr. Peyton are very prejudiced individuals.
Okay.
They had a robust gentleman from LaBelle, the name of Kane, provide yard care service until I raised the issue with the fact that he kept raising fuel cost. But when I looked at a graph provided with about the cost of fuel over a 10-year period, it was pretty much now it was erratic, but it was
you've made. I think I understand your point. Is there anything else you want to add?
With regards to Dr. Grapon's report?
Yes, sir.
Okay, yes.
This is the focus of where we are.
Keep going. Let's see. He will admit there is no medical provider who has supported his opinion, and that that is the basis of his alleged medical problems. Actually, I would rewrite that as he will admit that there is no medical provider who has validated his hypothesis that is about symptoms that have experienced that are specific to electromagnetic hypersensitivity. Hypersensitive syndrome. I understand the need for independent third-party validation to my claims. Okay. And then the next sentence,
I
apparently.
know what
he
he's
is-
saying. I've read it on numerous sites. It's in the record. We're taking time up just repeating what's been said. I just want to know what you want to add that's not duplicative of what he has
okay.
already
Well,
stated.
I've
Thank you.
had a Latino tile worker notice a difference in the EMF readings I was getting on my cell phone after he removed a mesh work that was under the jacuzzi bench. Okay, so he's seen that for himself. I acknowledge myself that in the past, others have been described as delusional, but I possess the research skills to use appropriately designed applications to measure electromagnetic flux in the environment, take repeated measures that are reliable and concentrated in areas of my home, and to determine the direction of the source by the strength of the signals. I don't know if his wife is directly involved. I think it's more Mr. Payton and their yard man. They feed into one another. And certainly the yard man feeds into Miss Payton, particularly while Mr. Payton is not around.
Okay, you've expressed that sometimes before. What
Okay.
else, sir? We need to conclude this hearing and move forward.
I'm able to, okay. And I would not say so much that they are producing some type of electronic signal that is causing me various symptoms. They're generating these microwaves that are inducing symptoms separate from symptoms associated with HIV-associated neurocognitive disorder. So I'm able to distinguish that there is two issues. Let's see, by a process of reasoning called convergent validity. Okay.
What else?
Also, that these experiences are not present when I'm in other locales because of a lack of exposure to electromagnetic flux. Okay. So I do not think my judgment is impaired. However, a person exposed to these inductions can be under a great deal of emotional stress, such that, one might be desperate to stop them. I'm not keen on reacting or responding to any aggression that is shown towards me. Instead, I think of ways to arrest them so that people just expend their energies for nothing at all. They're not reinforced for them, and I'm not faulted for responding to them. And one of the ways is that I've bought 20 to 40 yards of Faraday fabric, which is fabric infused with copper and nickel particles that reduce the entry or the strength of electromagnetic waves into my home. And they have been exceedingly successful in doing so.
You've made that point. Conclude, please. Thank you.
Okay. I would take issue that that I can't provide a rationale for my experiences that can be validated independently, and that I do not, I'm not mentally ill in the sense that I have an emotional or affective disorder, but rather I have neurocognitive deficits that are consistent with the dopaminergic reward system in the brain and its purpose. Okay. I am willing to accept voluntary psychiatric admission to Methodist Hospital under the care of Dr. Vo and Dr. DeLay. I do have insight into my condition. In fact, because a PhD teaches MDs, I often educate them about my condition, and I can provide research reports to back up my opinions. So I suppose that's by and large everything I could add.
All right. The court, what you are telling this court, do you stand by its accuracy, the accuracy of what you have told this court under oath?
Yes,
And is this the same accuracy that you have used in the interactions with this court in the past when you speak to the court or make statements to the court? Is it that same accuracy that you have used in the past?
yes,
Okay.
yes.
All right. I'm going to remind you, you remember when I think one of our first meetings, you called me a drunkard. And we all heard that. And that I had a reputation of being a drunkard when I don't drink alcohol. Do you remember that?
Well,
Do you remember that? See,
yes, I
the point
remember
is
that. Yes,
that-
and there was some basis for me saying that.
There was, God bless you.
Yes.
Well,
Yes.
were you mistaking me for somebody else?
No,
Oh, okay. Well, okay.
No.
Everybody, this whole town-
You were identified as attending a
this
meal?
court does not drink alcohol.
Okay.
And, that's, I've
Okay.
never, I'm a soft
Well,
drinker
I
and that's
was
the way I
informed by a
am.
gentleman that whom I had no reason to question his validity
All right.
since he worked as a waiter there at my restaurant.
All right. This court doesn't purchase alcohol from businesses.
And there was also an alternative
restaurants. I don't,
hypothesis.
but that's
Because of your
that's
tremors.
that's the first time I've ever heard that one. But in this job, this court is not surprised of what can be said, but it's what is supported.
Well, have you taken medication before? Are you
Sir?
taking medication now for your tremors?
Oh, my familial tremors,
Yes.
which you see, that's another thing.
Are you
These
taking
are my, this is, you have misdiagnosed this as well. Yes, everybody knows that this court has what's called familial tremors. I got it from my mother. My mother had it, and so it was passed on.
I
But
understand.
I also have am an artist. I'm able to control those, and no, I don't even take medicine for it. I've only had it my whole life, and it has not affected anything to do with my ability to think, function, and that's, you and I are completely different, sir. This is apples and oranges, what we're talking about. And this court there's been never been a question about this court's competency, nor a question of this court's ability to conduct myself physically. And I actually still run in the 10K whenever I can. I think it's pretty good. And I played sports, but I think if you of all people shouldn't be making conclusions when you don't have the basis of it. And if you know anything about familial tremors, you know it has nothing to do with competency and incompetency, and it is one of those situations that's traceable. That is of all human qualities, one of the least problematic of all. You are the function of, you are the focus of this.
There are
You
some
and your
conditions
actions,
in which
you
people
have-
are not
I'm sorry,
aware
sir,
that
you
they are
interrupt.
having problems.
You interrupt, and we can't both speak when this court reporter is taking down. I've really had to scold people in the past, but I shouldn't be scolding somebody like you, except I've come to know enough hearings that you want to control every hearing. You want it on your terms. And the fact of the matter is, you were indicted by a grand jury. You have had hearings here where this court allowed you to post bond, and then you violated your bond conditions. And then the statements you have made, not only at this court about alcohol abuse. God, my goodness, everybody knows differently. And then you attribute that as familial tremors caused by alcohol inducement. That's bizarre. You know it, and I know it. You just don't have the basis of connecting that a physician should have in any education that you have had up to this point on making a diagnosis that of bizarre terms like you have made. But the point is you when you're here, you say things that roll the eyes of everyone. You accused your neighbors of attempting to harm, deliberately trying to harm you by using microwave energy with little or no basis. The rules of law will apply as they should in all cases here. Chapter 46B of the Texas Code of Criminal Procedure deals with incompetency to stand trial. Under 46B.004, the issue of competency to stand trial was raised, and it was suggested by your attorney on your behalf. The court ordered an analysis to be made by a competent physician, doctor of psychiatrist, Dr. Ed Rapine. He was an expert under 46B.022 who examined you, filed his report under Article 46B.025, and his report states that you are incompetent to stand trial and proceed to a resolution of your legal issues, that you are mentally ill. And from testimony of the neighbors, they fear for their safety because of the actions you have taken in your bizarre response to your theory that the neighbors are conspiring to harm you with electromagnetic energy. The law places the burden of the trial court to conduct the informal inquiry that this court has done, and that resulted in the ordering of the examination on competency. Some evidence standard is met, and this to proceed to the competency issue, there is a bona fide doubt standard for determining whether there should be an inquiry that this court reasoned was valid, and that the court may make an initial determination of your competency to determine whether examination should be made not only based upon the court's own observations, but other information the court may receive in its hearings, and may make a determination on competency based not only on the court's own observations, but also with a psychiatrist's report as been submitted in this case. Thus, the issue of competency is before this court, and this court deems that the evidence supports fully that the defendant is incompetent to stand trial and is unlikely to be restored to competency in the foreseeable future, based upon the information from previous hearings, and then most importantly, the evidence submitted from court's exhibit number 1, admitted without objection, Dr. Ed Rapine's report, and the other statements, bizarre statements that are being expressed by this defendant. So, Dr. Bordash, the court will deem you at this time to be medically deemed incompetent. We are going to transfer you to the proper state medical facility where treatment will be made for you and that you will hopefully cooperate in that treatment. And our whole hope is that one day soon, hopefully, that competency will be restored to you. And this court will sign the appropriate orders to ensure that that shall be accomplished. Anything else to be added by the state?
No, Your Honor.
Added by the defense?
No.
All right, we are in recess on this. That is all. Here's this.